Good morning, everyone, and good afternoon to those of us here in Ontario. Welcome to our Labour, Employment and Human Rights webinar, Navigating Legal Complexities in Executive Compensation. My name is Alix, and I'm a partner in the Labour, Employment and Human Rights group. Before I introduce my co-presenters, please see the administrative information that are outlined in the screen. I'd like to draw your attention to the survey and the CPD certificate points. You don't want to miss those. QR codes and links will be available at the end of the event to fill out our survey and to obtain your Ontario, Quebec, or BC CPD credits. We'd appreciate it if you could take a minute to fill out our survey as well. Turning to my fellow presenters, Anthony Panacci and I are both partners in the Labour Employment Group and part of our executive compensation subgroup. We provide advice to clients on executive agreements and equity plans and the full gamut of labor, employment, and human rights matters. Kevin Yep, our smarter partner, is a partner in our tax group. He focuses on domestic and international tax planning, corporate reorganizations, and mergers and acquisitions. He regularly advises clients on executive compensation and tax issues related to investment funds, financial institutions, and technology companies. Kevin, Anthony, and I work closely on executive compensation matters. So turning to our presentation for today, we're going to be exploring the complexities of executive compensation in the private sector. Whether you're designing incentive plans, navigating tax implications, or managing terminations, understanding the legal framework is both essential and helpful. Our goal is to unpack the key elements, highlight some common pitfalls, and share some practical insights to help you structure executive compensation plans and agreements to be both effective and compliant. I'm going to turn it over to Anthony.
Thank you, Alix. Okay, so before we jump into sort of the details and nuances of incentive compensation, I'd like to first provide an overview, provide some context for what compensation packages look like generally speaking, because that'll help us understand how the pieces fit together and help us understand why some of these nuances exist, why we have different forms of incentive compensation. So generally speaking, the different types of compensation can be grouped into two buckets. The first bucket, I'll call them fixed elements of compensation. These are elements that almost everyone is familiar with. If you worked a job, it's your base salary and other benefits and perquisites. So as long as the executive is showing up for work, providing their services as an employee, they're going to be getting their regular base salary on the fixed payroll cycle. They'll continue participating in group benefits, and they'll continue getting whatever other perquisites they've agreed to, whatever other perquisites have been agreed to. Perquisites like a car allowance, maybe medical services like health examinations, possibly memberships in professional associations. The second bucket are what I will call at-risk elements, the reason being that there is some risk the employee or the executive will not actually receive the compensation, even though they've been showing up to work, even though they've been working. There's a risk that they might not get the compensation at the end of the day. Whether that's because certain conditions have not been met that needed to be met for the employee to be eligible or to get the compensation. For example, performance criteria, performance conditions, or vesting conditions, and we'll get into that in more detail shortly. Now, there's a variety of factors that will influence the particular mix of compensation between the fixed elements and the at-risk elements. I've listed some of the more common factors here. The main or one of the largest drivers being balance. You want to have a balanced compensation package that provides that doesn't incentivize bad behavior on the part of the executive, that incentivizes the executive to achieve the outcomes that you're looking for as an organization. So, historically, executive compensation, if you were to rewind, let's say 60, 70 years ago, really you'd be looking at base salary plus some perquisites, maybe some form of cash bonus, maybe. But generally speaking, base salary was the majority, if not all, of the executive compensation package. But in that scenario, there's no real incentives. You're relying on the executive's internal motivation and essentially their fear of losing their job, that if they don't perform, they're not going to have money coming in the door. So, those aren't ideal incentives. You don't want to be relying on those if you don't have to. And so, to deal with that, you then add in short-term incentives into the mix. If the company performs well this year, the executive will get a bonus and is rewarded for their performance. But then again, that also has some downsides. If you're only providing base salary and you're only providing short-term incentives, you're incentivizing short-term growth, and short-sighted decisions can have significant consequences down the road. So, for example, if you're incentivizing short-term performance, you might incentivize the executive to, let's say, cut all maintenance costs. If you're in the manufacturing industry, you might incentivize the executive to not perform any maintenance that year. That way you drive costs down, or the fees associated with that. Profits increase that year. The executive receives a healthy bonus at the end of the year because the performance that year was great. But then next year you have all these problems, and that's not dealt with through your short-term incentive plan. So then what do you do to deal with that? You add in long-term incentives, and the long-term incentives typically are more than a year. Plans that contemplate a payout some years down the road that's more than a year from the day that the plan starts, or the day that the award is granted, the conditional award. Other factors are, and it's tied in with that as well, is you want to align the executive's interests with the interests of the company and with stakeholders and shareholders. The reason being that, let's say you give an executive incentive compensation in the form of equity, shares in the company. You are effectively putting the executive in the shoes of the company, in the shoes of shareholders. And so if the executive takes actions that are for the good, for the better of the company, for the better of shareholders, the executive will also benefit from that. Those actions are also for the benefit of the executive himself or herself. And so one of the factors is you want to align the executive's interests with the company and stakeholders. Peer groups will also drive or influence compensation packages. The reason being that a lot of times companies will, when they're figuring out what's the appropriate mix, what's the appropriate base salary, what's the appropriate level of incentive compensation to be awarding, they'll want to know what's market. And some organizations will want to be at market. Some organizations will want to be above market. But ultimately, the key factor here is you don't want to lose your top talent to a competitor because you're underpaying, you're undercompensating. And you also need to offer a package that will attract talent to your organization. You're not going to be able to hire top candidates if you're not offering a competitive compensation package. So peer groups will also influence the mix. And then the last factor I have here, it goes without saying, laws and regulations will influence what a compensation package looks like. But the reason I've highlighted it here is because over time, the laws and regulations change. The laws and regulations make some forms of incentive compensation or some forms of compensation more attractive. Sometimes the changes will make certain forms less attractive. And so over time, you will see shifts, as we've seen shifts from base salary to other forms of incentives. We could move on to the next slide, please. The next one as well. And so that's sort of the general context that I wanted to provide just to set the stage here. And we'll hone in a little bit more on short-term incentives and long-term incentives. So short-term incentives, what are we talking about? We're generally talking about plans that contemplate a payout after a one-year time frame or some shorter time frame. Could be, for example, you might have a plan that pays out quarterly, does quarterly performance assessments, pays out every quarter. You might have a plan that is based on the fiscal year. You look at the results of the fiscal year and then pay out afterwards within a couple months. But generally speaking, you're looking at a year or shorter. we're also typically talking about a plan that provides for some variation of cash. Again, possible to have other types of entitlements under short-term incentive plans, but generally speaking, what you most often see are some form of cash payment if performance criteria are met, or if the conditions are met in the plan. And so just to provide you with an example for some more context, I provided a sample here on the slide. And what you might see is an employment agreement that says, the executive will be paid a base salary of, let's say, $300,000. You'll have another clause that says, for the executive will be eligible to participate in the company's short-term incentive plan. For the purposes of that plan, the executive's target will be 50% of a base salary. I'm just using that as an example number, but it might say 50% of the executive's base salary. And so if the plan criteria, if the company performs at target, at expectations, if the employee performs at target, at expectations, the employee will receive that target bonus, and it'll be 50% of the base salary, a payment of that amount at the end of the fiscal year, or whatever the plan period is. Now, the plan itself will typically have or provide for some ability to adjust the amount of the payment based on company performance, based on individual performance, and it's done through multipliers. So again, here, just as an example, there's a million ways of doing this, but you might have a plan that says if the company performs at target, the multiplier will be 1 or 100%. If individual performance is at target, the multiplier will be 1 or 100%. And so again, at target, it results in the target percentage payout. If it's below target, if the company has a bad year, doesn't meet expectations, doesn't meet targets, that will reduce the multiplier. And when it gets plugged into the formula, it results in a reduction of the overall payment. Same thing for individual performance as well. And so one of the questions that came up is, are you able to reduce compensation if the company has a bad year? And then what are the implications of doing that? And I figured I would deal with that now, because now I think is an appropriate time instead of waiting until the end. But the major concern that you're typically looking at where you are reducing compensation without an employee's consent is a risk of a constructive dismissal claim. There's obviously other types of legal implications, but that's typically the most significant risk. One of the ways you can mitigate that is by having compensation structures that provide for short-term incentives, or whatever form of incentive compensation, and then ensuring that your incentive compensation plan provides for that flexibility. So that if the company does have a bad year, it's reflected in the corporate multiplier. It automatically reduces the bonus payment that would be paid out. So that's one way of addressing it. If you don't have a plan that does that, you might not have the ability immediately. I mean, there's strategies to implement reductions of compensation, but that's sort of beyond the scope of today. And the last thing I'd want to flag here in terms of short-term compensation, short-term incentive compensation, is that even though typically you will see some form of cash involved, some companies will offer the ability to defer the cash payment into the future, and sometimes it's even in deferred share units. So instead of receiving a payment of $100,000 today and getting taxed on it at the highest tax rate, the executive might have the ability to, instead of receiving it today, receive it at some point in the future in the form of deferred share units that only the employee only has the right to receive after the employment relationship has ended. And through that, I mean, Kevin will get into the tax implications later on of the various types of compensation, but we don't see it very often because it incentivizes an employee to leave, because that's the only way that they're able to get the compensation. So on that note, I'll move into long-term incentive plans now. And there's a long list of different types of entitlements that can be granted under the umbrella of long-term incentive compensation, different types of different forms of rights. But what I've done here is I've just listed the three most common ones that we see nowadays, and which are stock options, restricted share units, and performance share units. I say most common in Canada. Due to tax implications, there's differences in the US. And so that's why I've also flagged here that when you're thinking about executive compensation, when you're reading about executive compensation generally, or when you're looking at your plans and your reward agreements, especially if they've been drafted for use in a different jurisdiction, whether that's the United States or Europe, the terminology that's used in the plan doesn't necessarily or accurately reflect what the plan is providing. Because terminology in Canada might mean something different in a different jurisdiction, and I've seen that, and it often happens with with terminology for things like vesting and exercisability. They're used interchangeably when they're not necessarily interchangeable. You'll sometimes see terminology like restricted share units when really the employee is getting restricted stock. So just be cautious and be alert to this issue as we're talking through this section. So in terms of stock options, what are stock options? So stock options are the type of compensation that an employee will get where the company grants the ability or grants the employee the right to purchase shares in the company at a predetermined price at some point in the future, and typically only after the employee has satisfied some conditions. So for example, if the employee has been employed with the company for 3 years. The benefit to the employee is that if the company performs well and the share price increases, the employee can then purchase the shares at a discounted price. So for example, a company might grant the employee right to buy 1,000 shares at $25 a share. And if the price goes up to 100, that's an increase of $75 per share. And if the employee were to then exercise the option, they'd be looking at a profit of $75,000. Some terminology that's just useful to be aware of. The strike price, when we talk about strike price, we're talking about the price that's fixed in the award agreement, the price that the employee would need to pay to purchase the stock. You'll often hear the phrase in the money, the options are in the money. That simply means that the strike price is less than the market price. So if the employee were to exercise the option, they'd be buying the shares at a discounted price and would be turning a profit. If the shares are underwater, that just means the options have no value at the current time, because if the employee were to exercise the options, they'd be paying more than what they could pay if they were to just go and buy the shares on the open market. Restricted share units, another common type of incentive structure. These are units that represent a potential right to receive a share in the company at some point in the future. And as I was talking earlier, there's a difference between share units and stock or shares. Under restricted share unit plans, the employee is not actually getting a share when the award is granted to them. They're granted a share unit that when it vests 3 years down the road, the employee at that point will then have the right to receive the share, or in some scenarios, receive a cash equivalent of the share. Performance share units. These are similar to restricted share units and are becoming increasingly popular. They're one of the predominant forms of incentive compensation nowadays. And essentially, it's a variation of a restricted share unit, except that typically, in addition to a period of employment as a condition of vesting. So for example, the employee has to be employed for 3 years before the restricted share unit vests. There is also a performance condition that needs to be met. So not only does the employee have to be employed for 3 years, the company has to meet certain performance targets in that 3-year period in order for the units to vest. If either of those conditions are not met, the units don't vest and the employee doesn't get the shares. So similar concept, but it ties the incentive to performance as opposed to just the employee being employed by the company. We'll move on. Yes, so here we've listed some other forms of compensation that you might see. Again, not necessarily the most common, but we do see these from time to time, depending on what the company is trying to achieve, depending on whether the company is privately held versus publicly held. Deferred share units, we've talked about that already. Those are units that will vest typically only once the employee leaves the organization. You have phantom stock plans, similar to regular stock plans or restricted share unit plans, except that under these plans, the employee is not actually getting any form of shares or any form of equity in the company. It's just a notional unit. So the idea is that instead of under a phantom stock plan, what might happen is company grants an employee a notional number of units. When those units vest, the company will effectively buy those units from the employee, give the employee a cash payment equal to the value of whatever those units are, or whatever the value of the company's stock is at the current time. So essentially, it's a cash variation based on the company's stock price. Stock appreciation rights are similar to a phantom stock plan, except that when the employee receives the cash payment, it's not a payment for the value of a company's share. Instead, it's a payment that's equal to the increase in the company's share. So let's say the company gives the employee an award of 100 stock appreciation rights, units of stock appreciation rights. If the company's stock is valued at $1 per share, these numbers are obviously very low for what you might see in reality, but for simplicity's sake, you have 100 share units, 100 stock appreciation rights at a dollar per unit. When the award vests, if the company's stock is still valued at $1 per share, there has been no appreciation, there has been no increase, so the employee doesn't get any cash payment. If the units, however, have increased to $2 per unit, now you're looking at an appreciation of $1 per share. And so in that scenario, the employee would get some form of payout. And then the last type of incentive compensation that I've flagged here are stock purchase plans. These are typically plans that will allow an employee to purchase company stock at a discounted price. What you might see is a plan that requires or allows the employee to contribute a certain amount of money to a pool periodically, and then at the end of the year, whatever money has been pooled will be used to purchase company stock at a purchase price. And the company might also offer to contribute a certain amount of money if the employee is participating in that plan. So the company might, for example, match the employee's contributions that are made through payroll deductions. I've mentioned this already, but the concept of vesting is critical and is used in many forms of incentive compensation. And there's different types of vesting. So, for example, the company could award an employee an award of stock options that will vest after 3 years. So let's say there's an award of 1,000 stock options that will vest at the end of 3 years. If the entire award vests only if that 3-year period is completed, we're talking about cliff vesting. The entire award will vest once you hit that mark. It's more common just to see partial vesting in a lot of agreements. So you might see, for example, an award of 1,000 units, but a third of that will vest after the first year that the employee is employed with the company. Another third will vest after the second year, and then the final third will vest at the end of the third year. And so here, there's different types of vesting conditions. So we've just talked about time. 3 years is a typical schedule. But there's also other options. You might have a milestone, for example. The company might grant an award that's conditional on the company securing funding, or the company completing certain projects, or successfully completing an acquisition of another company. And then the last type of condition here that I find is performance. So again, certain performance targets are established. If those targets are met, the award will then vest. And as I mentioned earlier, vesting and exercisability, sometimes those terms are used interchangeably, but they're actually distinct, at least here in Canada. Vesting, when we're talking about vesting, we're talking about the day when the employee actually acquires the conditional right. It's no longer conditional. It becomes an actual entitlement of the employee. Exercisability is the ability of that employee to act on the right that has now vested. And so you might have stock options, you might have share units that have vested, but you can also include limitations on when and how the employee can exercise those rights. So they are different. Again, I've seen them used interchangeably when they really are not. And then the last topic I wanted to touch on for context here is that when we're talking about privately held companies, compensation packages tend to look a little bit different than publicly held companies for various reasons. So when we're looking at a publicly held organization, one of the major differences is that compensation there are disclosure and reporting obligations for named executive officers. So the top paid executives, their compensation packages have to be detailed in the circular that gets provided to shareholders. It's also easier to value and dispose of equity when we're looking at a publicly held company, because shares can be sold on the market. There's a public stock exchange where the stock price is listed and it changes on a day-to-day basis, on a minute-by-minute basis. And so, I've just provided this as a sample. This is not necessarily reflective of what every company will do. There's lots of variations, but I've provided this just to give you a general sense of what a compensation package might look like. So you might have an executive whose compensation package consists of 20% is made up of their base salary, 20% is made up of short-term incentives, and then the remainder is made up of long-term incentives. And that might be split between performance share unit plan, restricted share unit plan, or stock option plans. Now, when we're talking about privately held organizations, they're not subject to the same disclosure rules. So you have some less scrutiny when designing compensation programs. And if we could turn to the next slide as well. Thank you. Again, you don't have the same type of liquid market where shares in the company can easily be sold. And so because of those factors, share unit plans are less common. You might see stock options where stock options are granted to, let's say, a founder of an organization on the idea that the goal is for the company to go public, or the goal is for the company to be acquired at some point. When the company is bought out or when the company goes public, the executive will benefit from the increase of their options, the increase of the shares that they have the right to purchase. So with that, I'll turn it over to Kevin, who will dive a little bit more into the nuances of taxation that drive a lot of this.
Thank you, Anthony. Anthony did a really good job explaining the different types of equity incentive plans that we typically see. There's a lot of them. Some we see more than others. It can be confusing. And one of the ways that your tax advisor will try to make it less confusing is to actually just help you focus on different factors that have a commercial and a tax implications. I recognize that for people who are not tax practitioners, sometimes when you have a question about some of these things and you ask your tax advisor, they'll give an answer, and that makes sense, right? And then maybe another time you ask this, maybe the plan's slightly different, and then you ask your tax advisor, and then you get like a completely different answer, or an answer that you don't remember being the same as what it was before. I assure you that your tax advisor should, it's not that it's inconsistent, it's that they've been paying attention and they've noticed, and there's been changes in the facts, which that could bring you into a completely different tax regime. And so the next few slides, I'm going to try to talk about some of these major aspects of these equity incentive plans that will change the tax consequences. I'm going to avoid getting into the nitty-gritty detail about the traps and the conditions and the requirements and the drafting that your that your advisors worry about and lose sleep over, but rather I wanted you to try to understand kind of like the main rules and how we fall into one regime or another. And so as we go through the slides, the three things I want you to pay attention to is the first one is I have a definition of it later on, but whether or not the employer or the issuer is a Canadian-controlled private company versus a non-Canadian-controlled private company. So the difference between a private company in Canada or a public company in Canada, or for example, a situation could be like a startup or a private company in the US that has a Canadian sub, and there's a plan that affects Canadian employees. The other thing that makes a big difference in terms of how we structure these is whether or not at the end when the award vests and it's settled, like the employee actually gets something, whether or not it's settled in stock or shares or securities, however you want to call it, like just like shares of the employer or the parent company or some other corporation related to or not arm's length to the actual employer, or if it's settled by cash. And the third thing is what is often very important to employees, obviously, is in certain conditions, which we'll get into, there's a 50% deduction. And just to explain that a little bit more thoroughly, the way to think about equity incentive awards is it's essentially remuneration. It's like instead of cash remuneration, it could be cash settled, it could be cash remuneration, or it could be shares. But there's a taxable employment benefit, and in certain conditions, you don't get capital gains treatment, but you get a deduction of 50% of the taxable employment benefit. So it's kind of like a capital gain. So it's kind of like capital gains treatment. So like it's obviously something that if that employees would like, which probably explains why you see stock options more than some of these other types of plans. So I'm going to advance the slide here. Anthony has talked about a lot of different commercial reasons or employee retention reasons why you want to design plans the way you do. But your tax advisor is worried about different things, some of them being deductibility and withholding. But from the employee's perspective, one of the main things we want to make sure is to the extent possible, you don't have a situation where the employee has a tax event without actually having the money to pay for it. And so like we just don't want like the timing between when the benefit is taxed and when they actually get the actual something like they can pay, they actually get the value, or they can actually have enough money to pay the tax. But just starting from the beginning. So employees are unlike a business or a company, which are taxed when something is receivable. Its employees are required to include an income when they get paid salary, wages, remuneration received in the year, and any benefits. So including taxable benefits like perks and tax. There's an entire area about what's a taxable benefit and not a taxable benefit. But any taxable benefits received or enjoyed, by virtue of their employment. And there's three main exceptions to this. Some work in favor of the employee, and some don't. The exceptions are a salary deferral arrangement, which we will talk about, constructive receipt, which we won't talk too much about, but it's essentially the situation where an employee has essentially the right to a payment, but then they themselves ask for a deferral, and so that's considered to be inappropriate because they actually they actually were able to get the money, but for tax reasons they might have asked for it to be deferred until a later year. And also, the main one we're talking about, and I apologize for referring to section numbers in the Income Tax Act, but I think I'm only going to give like two of them. Well, two, and the second one has a lot of sub-paragraphs, but the main one that I think is not too bad if I mention is Section 7, which applies to agreements to sell or issue securities, which is you do want that to apply if that's your intention. Next slide. So let's first talk about salary deferral arrangements. So salary deferral arrangements, essentially what it's intended, it's an anti-avoidance rule. What it's intended to do is, it's a definition or a rule inside the Income Tax Act that does not allow salary to be deferred for an inappropriate amount of time. Technically, the definition does have a purpose test, so it makes it a bit of an anti-avoidance rule, that there has to be like a purpose to postpone tax. But in reality and in practice, that condition of it isn't really, we don't put that much reliance on that from the employer's perspective, at least, mainly because there's a pretty common exception that most people rely on. And so these apply to, and so you'll hear in this slide and also in later slides, this concept of a 3-year bonus exception. So essentially it's an exception to the salary deferral arrangements if the deferral or payment or bonus or similar payment is paid within 3 years following the end of the year of service. There's also other statutory arrangements that are clearly not that are explicitly not salary deferral arrangements, including registered pension plans, the deferred stock units or deferred share units that Anthony referred to before. So again, recall that a couple slides ago I said your tax advisor wants to make sure that that the timing of the tax event and the receipt of the value occurs at the same time. So one of the things we really worry about is to make sure that the salary deferral arrangements do not apply. So get you into deferred stock unit, a registered pension plan, or this 3-year bonus exception regime that gets you out of this. So Section 7. So Section 7 is good, assuming that's what's intended, and it applies to agreements to issue or sell securities. Some people say, and even if you look at the CRA website, if you Google Section 7 and CRA, they'll talk about some of these rules, and they'll use the word stock option a lot when talking about Section 7. But Section 7 is actually much broader than that. It applies to agreements to sell or issue securities. So one of the ways, if you want to think like a tax lawyer or tax accountant or tax advisor, one of the ways to simplify in your brain the different types of equity incentive plans is to think about what's caught under Section 7 and what's not. So if you're in Section 7, then it's excluded from the salary deferral arrangement rules. Stock options, we've heard that is clearly an agreement to issue and sell securities. But some of the other things that Anthony mentioned too are like a stock purchase plan, where someone can, or a stock bonus, where there's an agreement to issue the securities to the employee, or a RSU, a restricted stock unit or performance stock unit, assuming, of course, that it's settled by the issuance of securities, right? And so that was one of the main distinctions in how you know which regime you fall under. Often your tax advisor will say like, well, okay, if you have this equity incentive plan and there's discretion for the employer or the issuer or the parent US or the parent company to either cash settle or share or stock settle these incentive plans, that according to this TransAlta case in the CRA, that doesn't get into Section 7 because that's not a binding agreement to issue or sell securities. So I'm trying to not get into the traps and the details, but one thing your tax advisor will try very hard to do is make sure that if you want to be in Section 7, that it's clearly an agreement to issue and sell securities, and it's not like the employer doesn't have the discretion to cash settle unless that's the plan that we're trying to get into. And so, the point here is if you're not in Section 7, then you worry about the SDA rules, such as the example being the cash settled RSUs. So let's just talk about one of the most common types of equity incentive plans, which is employee stock options. So Anthony kind of explained how it generally works. And from a tax perspective, I think what it's important to understand is if you're in Section 7, then on the grant, there's no taxable event. And that's very important, right? Because I can distinguish I can distinguish an employee stock option from a stock option issued to independent contractors. And Section 7 applies to the former, but not to the latter. And so there's a lot more certainty in tax treatment because it's very clear that there is no, even though that theoretically there is some value being given to the employee, there's no tax event on the grantor entering into the agreement. Eventually, there is a employee stock option benefit, and that essentially is for stock option, the value of the shares that are issued on settlement less the exercise price on the acquisition. So essentially, like how much the value of the shares you get less how much you had to pay for it. So in a stock option, that's the strike price, and that's all that stuff I told you is common between a private company stock option and a public or non-CCPC stock option. But what's important to know is that there is a CCPC stock option has an additional benefit, and the policy reason, before I get into detail, and this will help you remember why it's the case. You recall that Anthony mentioned that if the shares being issued are a publicly traded company, then then there's a liquid market for it, right? So it's easier to figure out how much it is, but it's also easier to sell, right? But in a private company, there's less information, so there's less liquid market. So in order, and also to possibly support Canadian businesses and Canadian private companies, they also give you an additional benefit, which is deferring when the benefit occurs. And I'll get into details about that in a second. But before we get there, I just wanted to show you the slide for exactly what a CCPC is. So Canadian Controlled Private Corporation, essentially it's the company is to be resident and incorporated in Canada, and it can't be controlled indirectly or directly by any combination of non-residents or public companies. So often it's very clear, like if it's all the shareholders are Canadian in the private company, if it's a it's a public company, it's not a CCPC, or those are those two examples. And the third one we often see is like a private company, but like not a Canadian one. Like if it's like a US startup, for example, or like a startup, any startup or any other private or even a large corporate private company in that's not Canadian, then they can't benefit from the employee, even though they might have Canadian employees, they don't benefit from the CCPC deferrals. So the main reason I think, at least, that stock options are popular is this availability of this 50% deduction. And there's two ways to get it. One way is only available to CCPCs, and the reason is consistent with what we told you before about liquidity and difficulties of value. But the main way to do it is what we call, and I again apologize for section references, but I need to tell you these because these numbers, like these sections, like show up in CRA guidance and tax returns like that. So it's good to know. It's good to know them. The main one is this 110(1)(d) deduction, and so the shares have to be prescribed shares, which is generally common shares, like I said. But the main condition is that it cannot, when the stock options are granted, they cannot be already in the money, right? That's and you'll remember that Anthony explained what that was. Other way to look at it is they can't have the exercise price cannot be less than the fair market value at the time of the grant. Generally, because of other rules in the US and I guess market practice, a stock option is granted and with the exercise price equal to the fair market value. In practice, that's not that hard to do for public companies. In practice, it's harder to do for private companies. And whether it's Canadian or if it's like a US private or US or other non-Canadian private company, so that's harder to do. without getting into too much detail, there's ways to get valuations, and sometimes there's valuations for IRS purposes or other tax authorities that you might be able to piggyback off of. But it is an issue, and that's one reason why there's a CCPC stock option deduction availability, and that's 110(1)(d)(1), where shares are held for at least 2 years after they've been after the option has been exercised, it's been acquired. So it's a little bit easier. Then you have to hold it for a bit longer, but then you'll note that it doesn't have that that exercise price equal to not being less than fair market value at the time of grant. The other thing I should mention, again, without getting into too much detail, because it doesn't really apply to that many companies, is that there's something called non-qualified securities. There was a bit, these rules came in about, I think, 3 or 4 years ago now. And what they're intended, and what they do is they essentially set an annual vesting limit of $200,000 a year, by which an employee is able to get this 110(1)(d) deduction. And so, but the rule only applies if you're not a CCPC and the gross revenues on a consolidated basis exceeds $500 million Canadian. So it's like these are the really big companies, either foreign or public companies, where and there's other conditions and filing requirements and notification requirements that deal with that. But but often one of the first questions I ask, which is kind of a strange question if you think about it, it's like someone asking me to look at a stock option. I'll be like, oh, well, is your revenue in excess of $500 million? And sometimes it's and when it's over that, or if it's close, I'd be like, oh, congratulations, that's great. But you have to worry. But you have to deal with this extra stuff. So here's a bit of a chart to kind of summarize the difference. So again, it's the key part of the most important part of why we want Section 7 to apply is that it's very, very clear that there's no taxable event to the employee on grant. And also vesting. I mean, assuming that vesting doesn't automatically result in the acquisition of the shares. Then that's more of an RSU thing. And then when there's a exercise of the acquisition of shares, and then from a non-CCP perspective, that's when the employee stock option benefit occurs. And again, that's like how much the value of the shares you get, less how much you paid for it. If it's a CCPC, then it's a deferral of the stock option benefit until the disposition of the shares. And then when you dispose of the shares, in both cases, there's a calculation of, then it doesn't become it's not an employee benefit anymore. It's because you own the shares, right? You're a shareholder. Then it becomes taxed as a gain or loss, depending on how much it has increased or decreased since the shares were acquired. There's a 50% deduction eligibility. There's different ways to meet it, and there's the payroll withholding requirement also differs. If it's a CCPC deferral, then there's no payroll withholding, which is fair because there's a deferral in the benefit, so there's no withholding. And then there's also no withholding, but there's a reporting requirement when there's a disposition of the shares, which again, it's a bit of a sweetener for private entities in Canada. From a non-CC perspective, there is withholding required on exercise, but the employer is entitled to take into account the 110(1)(d) deduction if available. Sometimes again, without getting into details, what your tax advisors may worry about is if it's a stock option, then the employee has to pay the exercise price, and then there's a withholding requirement, but where does the money come from, right? Because if you're exercising shares and you're not selling it immediately, then there's no cash to withhold from. So care has to be taken to make sure that, depending on the magnitude of the amounts, whether or not the employee either comes in to either pays the amount that has to be withheld, and then the employer remits it, or what's common at least for public companies, is that you can have what's called a broker assisted sale. And then the broker essentially sells some shares to pay the exercise price and the tax liability. So there's different ways to deal with it, but it's an issue. It's probably it always has to be considered. It always has to be considered when you're not a CCPC. So let's talk about restricted stock units and performance stock units. So these are, so they're not stock, right? They're units. And so they are they're granted based on a formula. It's a long-term incentive plan. There's vesting conditions. The difference really between an RSU and a PSU, at least from a tax perspective, is that the RSU, typically the vesting conditions is like how long the person's working there and they haven't been fired yet or terminated yet. And then performance, there's a few more vesting conditions that are based on their like sales targets or other kind of performance related conditions. From a tax perspective, it doesn't really make a difference. What makes a difference is it's one of the things I alluded to at the beginning is it a agreement to issue or sell securities, i.e. Section 7, or is it I'm going to use the word phantom stock before I introduce in the slide. Is it cash settled, right? And therefore not an agreement to issue and sell securities because it's an agreement to pay you cash later, right? And so I kind of alluded to it too. If it's stock settled only, then you're in Section 7 and all the stuff I talked about before kind of applies, except for the stuff that doesn't. And then if it's cash settled, then we have to worry about salary deferral arrangements. So how do we do? So how do we take care of that? Well, the 3-year bonus exception plan, right? Sorry, the 3-year bonus exception to the SDA. So we will. So in Canada, most, probably all restricted stock units have a vesting period, and more specifically a vesting and payout period less than 3 years after the relevant year of service. Again, a way to kind of simplify, the cornucopia of different incentive plans that we threw at you is kind of just think about like the underlying features, right? Again, these are restricted stock units and performance stock units. They're actually Section 7. They're kind of like stock options, except that there's no exercise price, right? So what is that? You're not really paying anything for it, but it is an agreement to issue securities. But if you run through the logic, what does that actually mean? Well, again, stock settled, Section 7 grant, not a taxable event. I use the word exercise, I shouldn't say exercise, but it should say like on the acquisition of the shares, right? Again, the same rules apply. It's a taxable if it's non-CCPC, taxable employment benefit. It's a deferral if it's a CCPC, and then if you sell it afterwards, then it's capital treatment. But here's the difference. You recall that for the 110(1)(d) deduction, the exercise price can't be less than the fair market value on grant. But another way to think about RSUs is that it's the exercise price is 0, and the other way to think about it is it's not an option because why would you get something? Why would you not take it if it's free? But like if you think about it that way, it's very easy to understand that it's kind of like a stock option. You just don't get the 110(1)(d) deduction, right? Because it's always in the money, I guess. And then you recall that for the CCPC agreements, then you can do the 2-year holding period. If you hold it for 2 years, you get the 50% deduction. So now let's talk about cash settled. So phantom stock plans, Anthony alluded to. I think of phantom stock plans as essentially cash settled RSUs. And so they're units, you're not actually a shareholder, right? And they're taxable. They're taxable as an employee benefit when the cash is on the cash settlement. But the problem is, if it's settled for cash, that means it's not governed by Section 7, which means you need to be careful about the salary deferral arrangement rules, which is why we build in the 3-year bonus exception. Let's talk about 2 other things that are kind of like that are also agreements to issue and sell securities, but are not stock options technically, and not good. They're kind of like it, stock options, and they're not RSUs, but they're kind of like it. So employee stock purchase plans and stock bonuses. So stock bonus is maybe how's that different from RSUs? Well, the word is slightly different. Maybe it's not a long-term thing. It's like at the end of the year you get they'll give you a bonus instead of paying a bonus in stock. They pay you a bonus in instead of paying a bonus in cash, they pay you a bonus in stock. Restricted stock is kind of like that too. So you get stock as remuneration, or shares as remuneration. An employee stock purchase plan is typically where instead of a stock option where you have an exercise price, you get to purchase, and this has to be something where there's a liquid market, right? So you're entitled, because there has to be a value. I guess it could be private too. Like you're entitled to buy shares that are, but instead of at their fair market value, you get a discount for it. Like it's 10%. It's typical, maybe more. And so if you run it through and these are agreements to issue securities, you run it through the analysis, then what's the consequence? Well, we skip the grant part because, I guess when these are set up, there's no tax event, because it's Section 7 says there's no tax event on the grant or when you enter into the agreement. And then when you actually get the shares, either through the bonus or you purchase it through the purchase plan, then that's the acquisition. And then what's the taxable employment benefit? Well, it's the same concept. It's what were the value of the shares and how much you paid for it. So essentially for ESPP, it's the discount is the taxable benefit, right? And then same analysis, after you sell it, should be a capital gain. You should not, it depends on the numbers, but you probably wouldn't get the 110(1)(d) deduction because it wasn't granted at exercise price equal to greater than, I guess, fair market value, right? Because you're getting a discount. And also bonus, you're not paying anything for it. 110(1)(d)(1) might apply. And it's the same kind of timing thing. So you can see like how it's actually not that complicated if you kind of like understand what the different triggering aspects are. And so I only have two more other things to talk about. So one of them is deferred stock units, deferred share units. So these are a statutory type of arrangement. It's critical because these are like essentially very long-term incentive plans. Just like Anthony alluded to, they do kind of incentivize retirement or leaving or termination. But the reason they work from a tax perspective is because they're explicitly excluded from the salary deferral arrangement, so they can go past 3 years. And I think the key point is, and the reason it often doesn't work practically, is that I'm just going to move the slide up. Is that the triggering events are their payment has to be made like very shortly after, but after the retirement, death, or termination of the employee. And so because of this timing requirement, it's intended for senior executives who are probably incentivized other ways to stick around. But it's not, when this comes up, it's actually not, I don't like, we talk about it. I talk about it often with my clients, but it's not flexible enough in a lot of situations. And then finally, there's this interesting type of plan called the stock appreciation right. So these are cash settled, and it's kind of its own type of thing where it's not a salary deferral arrangement and even though it can be paid after 3 years, after the year in respect of the service year, and you don't have to wait until retirement, termination, or death. And so the theory behind it is that there's no value being granted to employees other than the increase in value of the shares for each particular year that they perform the service. The problem with these is the CRA has been kind of looking hard at them. I think a lot of employers have been trying to push the limit of what they can do with these stock appreciation rights. So there's been some recent interpretations that kind of narrow the conditions that must be satisfied in order for the SCA rules not to apply. And so this is an option. This is something that's doable still, but it's just not as flexible as some people might have thought they were in terms of the conditions and like the value and how much the value can increase. And so it must be drafted to carefully comply with the current positions, which basically means that it really has to, I mean, the main idea there is that it really has to only deal with an increase in the value of the underlying company and not really anything else, or no sales targets and things like that. So here's this kind of a table that kind of explains the different things. I won't get into too much detail now, but hopefully after listening to my part of this presentation, it's we gave you a list of lots of different things, but it's actually, if you kind of focus on 3 or 4 different features, it's actually not that complicated. It's actually quite it actually makes a bit of sense. And hopefully next time you ask your tax advisor and then they give you an answer which sounds like completely opposite of what they told you 2 weeks ago, then probably it was because one of these things changed. I'm going to pass to Alix.
We're going to move on. Thanks, Kim. We're going to move from some good tax advice over to how we deal with terminations, which, as we know, are complex, can trigger a range of entitlements beyond just base salary payment. They can obviously include equity awards, short and long-term incentive payments. Now, typically, employment agreements set out those entitlements for executives that occur on a termination without cause, and they can include a variety of payments. Some include just base, some include base incentive pay, some include equity, some don't. At the end of the day, if these agreements that you have with your executives are not enforceable, then the executive would be entitled to what we refer to as common or reasonable notice, which means they're basically entitled to everything, all their compensation and benefits, including short and long-term incentive payments. Now, obviously, termination liability increases significantly when employment agreements, if you have them and they're enforceable, are not aligned with the incentive plan language or the grant agreements, because courts will often interpret entitlements in favor of the employee if there are underlying inconsistencies between the various agreements. So we often have the situation, and many of our clients are not happy about this, where we have an employment agreement that states that the employer, the executive is only entitled to a certain salary payment at the time of termination, and under the bonus plan, it says that they're not entitled to it on termination. But because there's ambiguity in the underlying employment agreement, or it's not enforceable, the executive can often be entitled to both the salary and the equity and the short-term incentive bonus. So we always say it's critical to look at all documents together to ensure that you're actually consistent between what the executive is entitled to, or you're stating in the employment agreement that if there is an inconsistency, you're naming which agreement would apply. Now, moving to resignation, if an executive, if we go back a slide, if an executive resigns, then, and that resignation is clear and unequivocal, then the executive generally forfeits all entitlements to a severance, equity, and other benefits. However, if the resignation is for good reason, then these provisions will often allow an executive to resign, and then they are able to receive as if they were terminated without cause, either in respect of the employment agreement, a termination without cause, or a common law termination. So if we talk about the common triggers that typically will result in a good reason termination, this is often if you have significant changes to duties and responsibilities of the executive, or a change in the reporting structure, a reduction in salary or bonus, relocation beyond a defined distance, or removal of an executive from participating in an incentive plan. Those obviously could give rise to what we call a resignation for good reason. Typically within these clauses, you have language that says that there's a notice period that the executive must advise the employer of their position, that they have been basically terminated for good reason, or that they have the right to resign for good reason. And the company may have a period to cure whatever change has occurred that would give them the right to take that position. So obviously what becomes clear when you're dealing with these type of resignation for good reason clauses is that if you don't have them clearly defined in the employment agreement, they will often result in litigation if there's any ambiguity. If we can move to the next slide. We also have change of control provisions. Change of control provisions typically can also create a minefield for employers, but they can be a powerful tool for protecting executives during a change of control, and what happens to the executive when it happens, and what happens to the executive after the change of control. Now, typically a change of control is defined in an agreement. There's no sort of, definitive example of what a change of control is. It's typically defined in the employment agreement and sets out what circumstances would give rise to a change of control. These are typically if the company goes through a major transformation, for example, a sale of a majority of the shares of the company or the assets of the company, or a majority change in the board of directors. This will obviously trigger a change of control, and once a change of control is triggered, it allows an executive to claim enhanced severance entitlements. And sometimes what we see in these agreements is that the change of control entitlements can be even greater than what the executive gets if they're terminated on a without cause basis. Sometimes it could be the same, and sometimes it can be actually more. Now, there are two different types of change of control provisions, and a lot of my clients will call me and they'll send me provisions that say, I've seen this in another agreement. Do you think we could just use this in our agreement? You want to be very careful about the type of change of control provisions that you use. A single trigger change of control is a change of control that is activated merely by the actual change of control. So for example, if there's a sale of 50% of the shares of the company, that'll automatically result in a change of control, and the payments will be issued to the executive. At the end of the day, you don't want a single trigger, in my view. I mean, it's very favored towards an executive, but it doesn't actually work in the best interest of the employer, because if they sell the business or there's a change in the composition of the board and the change of control provision is triggered, that payment is made. Typically, what we recommend is that there's a double trigger change of control provision. This means that there has to be two things that occur. The first thing is that there's a change of control, and so there's a sale of a business, for example, and that there's a resulting termination without cause or resignation for good reason. And that is typically within a certain period of time following the sale of the business. So, and that's what we call the operative window. So for example, in a double trigger, first of all, there has to be a change of control. Then the executive has to be terminated, or they have to be, their terms of employment have to be fundamentally changed such that they can rely on a good reason resignation provision. And that has to occur within a certain period following the change of control. And we usually see 12 to 24 months following a change of control that the executive is allowed to trigger this double trigger change of control. And so on the one hand, you want to protect the executive from a new owner taking, liberties with their terms of employment or terminating them without cause and therefore allowing them to get a payment at that time. And so we usually say double triggers are in the best interest of both the company and the executive. Now, as we said, the amount will be negotiated with the executive and the company, and that can sometimes be even greater if the executive has played a huge role in getting the business to the place where it's being sold, and they want to reward the executive for that. The board can obviously provide a greater entitlement during a change of control versus if the executive is just terminated without cause. What's often really important is that executives need to have, if you're dealing at the C-suite level is to make sure that the board of directors understands what the financial implications and strategic rationale is for including these provisions in an executive agreement, because they can have significant financial consequences. Next slide. Now, many of you who speak to anyone in our group will know that one of the biggest challenges we have with executive employment agreements and other agreements is whether or not an employee is entitled to certain bonuses and long-term incentive plan payments after they've been terminated. And that's whether they're terminated with cause or without cause. And oftentimes we discuss the fact that there's been a recent decision by the Supreme Court of Canada that requires employers to really have clear and unambiguous language that is compliant with employment standards, that allows the employer not to pay out bonuses or long-term incentive payments during a termination without cause, or if they've been terminated and just paid out the employment standards entitlements. So the one decision that we obviously rely on is Ocean Nutrition. And I'll talk about that in a few seconds. What's also really important and what oftentimes get missed is whether or not we're communicating with employees around their entitlements on termination. So for executives, especially, it's really important to have them sign off on these agreements and ensure that the employee and the executive is aware of what happens if they are terminated on a without cause basis. Again, as I said at the beginning, if you have inconsistencies between the documents, this will often be interpreted in favor of the executive because there's ambiguity, because we haven't clarified which agreement actually applies on termination. So let's move to the Matthews and Ocean Nutrition decision. I often refer to this as the 2020 decision of the Supreme Court of Canada. It's a landmark decision. It's also a cautionary tale. Beginning in 1997, Matthews was an experienced chemist. He occupied several senior management positions with Ocean Nutrition, and he was part of their long-term incentive plan, which was a contractual arrangement which was designed to reward employees for their previous contributions and to provide incentive to continue to contribute to the company's success. And so under this LTIP, there was a realization event, such as a sale of the business, which would trigger payments to employees who qualified under the plan. Now, 10 years after Matthews had been hired, a new chief operating officer was hired who began a campaign to marginalize Matthews in the company. He limited his responsibilities. He would, according to Matthews, lie to him about his status and prospects with Ocean Nutrition. And so despite his problems with this new senior manager, Matthews wanted to stay because the LTIP was a key reason why he wanted to stick around. And he thought that the company would soon be sold. However, after a duration of being undermined in his view, in his role, he eventually left Ocean Nutrition in 2011, taking a position with a new company. And about 13 months after his departure, Ocean was sold for $540 million. The sale constituted a realization event for the purposes of the LTIP, and since Matthews was not actively employed on that date, the company took the position that he did not satisfy the terms of the plan, and therefore he was not actively employed and he was not entitled to a long-term incentive plan. Now, that long-term incentive plan was worth $1 million. So he clearly filed a claim against Ocean Nutrition, alleging that he had been constructively dismissed by the changes implemented by the chief operation officer, and that the trial judge therefore concluded that Ocean Nutrition had constructively dismissed Matthews. He was owed reasonable notice of 15 months. Since the sale occurred 13 months after his departure, he would have been a full-time active employee during the reasonable notice period, and when the realization event occurred, and that he was entitled to the long-term incentive plan payment. This obviously was appealed to the Ontario Court of Appeal, who unanimously upheld the decision that he was constructively dismissed and that his appropriate reasonable notice period was 15 months. However, the Court of Appeal found that Matthews was not entitled to damages on account of the lost long-term incentive payment. Moving on to the Supreme Court of Canada, never to be left undone. The Court of Appeals, the decision was set aside and the trial judgment was restored. So the Supreme Court of Canada ruled that the long-term incentive plan did not clearly remove Matthew's common law right to damages. Because the realization event had occurred during the reasonable notice period, he was entitled to that $1 million payment. What we learned from this decision, and what has impacted a lot of, especially our US clients who are trying to have their short and long-term plans applied here in Canada, is that if you do not have clear language that clearly and unambiguously limits an employee's entitlement on termination, the courts will allow their employees to have access to these short and long-term payments. What became very clear as well in the Ocean Nutrition decision was that you had to comply with the employment standards legislation. Employment standards legislation, obviously across Canada and in particular in Ontario, says that you cannot change an employee's terms and conditions of employment during their statutory notice period. And so you'll often have us draft agreements that ensure that the actively employed language that Matthews relied on successfully in his case is drafted in a way that's clear and unambiguous and includes that the employee is entitled to receive whatever they are entitled to receive during the statutory notice period. This often results in very lengthy language in agreements, which I know is not always ideal for some of our clients, but is really one of the only ways we are able to limit an entitlement to bonus following a termination without cause and to a long-term incentive payment. If we could move to the next slide. Now we come to the most recent decision in July 8th, which is the decision in Wigdor and Facebook Canada. This one, luckily enough, is more helpful to employers, but not as helpful, which is very unusual in Ontario because most of our decisions the last number of years have definitely gone in favor of employees. So we were quite excited about this decision when it came out. Dr. Wigdor was terminated from his employment at Facebook. He had restricted share units under multiple agreements. So as Kevin and Anthony were referencing earlier, you can get these restricted share units, but sometimes just restricted on a time-based basis or on a performance basis. And they could be each year, and they could be vesting over 3-year terms under separate type of RSU agreements. So under the terms of these agreements, upon his termination without cause, his unvested RSUs were forfeited. He brought obviously a claim against Facebook, arguing that forfeiture violated employment standards, which required that employers maintain terms and conditions of employment during the statutory notice period. Does that ring a bell? Because I just told you that that's what Ocean Nutrition really caused us to change when we drafted these agreements. And he claimed that RSUs should be considered wages or benefits under the employment standards legislation, and therefore they should continue to vest over the statutory notice period. The Ontario Superior Court disagreed. They found that RSUs were governed by separate agreements and not considered wages or benefits under the employment standards legislation. The RSU agreements clearly stated that vesting would cease upon termination, even if the termination was later found to be unlawful. So what we see in this case is that it highlights the importance of drafting clear forfeit language, ensuring RSUs are enforceable. Given that this is the first decision that states that this principle, applies under employment standards, we are still saying to our clients we should be wary because we understand that this decision is being appealed, and therefore we're still continuing to draft language that also complies with how we see Ocean Nutrition and the Supreme Court of Canada decision. But at least it gives us an opening to make these arguments if you do have current unenforceable language. So good news on this last decision. And now we'll move to the last slide. So I just want to wrap up today. I know there's a lot of dense material that we went through today, and hopefully it gave you some idea of the complexity of executive compensation, and that getting advice in this area is sometimes very helpful and can protect the company and executives when you're dealing with implementing plans and when you're drafting executive agreements. So cash entitlements are pretty straightforward. but we definitely see that equity and how you deal with stock can require some careful planning. So when we talk about litigation, it's possible, if possible, we say keep the executive on the plan until settlement. It's often cheaper and cleaner than cash compensation. Tax treatment matters always. Stock options may qualify for preferential tax rates while cash settlements do not. Canceling equity can lead to higher settlement demands to offset the tax loss, so you need to plan ahead before you do these terminations. Structure settlements to optimize tax outcomes and reduce litigation risk. When it comes to executive terminations, the details definitely matter, and a well-drafted agreement and a coordinated approach can prevent costly disputes and ensure a smooth transition for all parties involved. So I want to thank you for your attention today. I'm going to turn to Anthony to see if we have any questions that have come in during our presentation.
Yes, we have a few questions. The first is a question of clarifications. I'll raise this first. It's for Kevin. It's a question about the stock option summary slide. And the question says that on that slide, it says the disposition of shares for a non-CCPC, then ACB equals the amount paid to acquire the shares. Okay. The question is, isn't the ACB the amount paid exercise price plus the stock option benefit?
Yeah, so that's right. Sorry, thank you for the eagle-eyed audience member who spotted that. So I wasn't clear there. So when the option is exercised, right? Basically, it also applies to stock purchase plans and stock bonuses, right? It's when you acquire the shares, the cost is what you gave up for it. So that would include in the stock option the exercise price and the taxable benefit that arises from that. In a stock purchase plan, I know it wasn't in the slides, but in a stock purchase plan, the same idea. It would be the discounted price plus the discount. In a stock bonus, it would be because the entire amount is included as taxable benefit. That goes to the ACB too. So essentially, like if you're taxed on it, I mean, I guess in my head I was thinking you're paying for it because you're taxed on it. But that's absolutely right. That reference was not clear. Apologize for that.
And I'll stick on the theme of tax here for a moment. Another question was whether there's any unique aspects for not-for-profit organizations. Maybe you can touch on that for a moment.
So obviously, if it's a not-for-profit organization, you can't really do anything that's stock settled. It doesn't really make sense to give membership interest, I guess, to employees, and so it has to be cash settled. I don't have any information on what people typically do, but from a income tax perspective, I would just make sure that the compensation is, the word that tax authorities love to use, reasonable, because the rule generally is that you can pay, like nonprofits can, pay honoraria and salary and things like that to employees and directors if it's reasonable. And I would just make sure that it doesn't, and there's nothing in there that in kind of, if you have vesting conditions or performance conditions, I just want to make sure. I mean, it should be fine because the nonprofit should have a nonprofit purpose, and everything they're doing should be for purposes other than profit. So I would just worry if I were reading some of these, if I were looking at the documentation, to make sure that there's nothing that kind of suggests that there is a profit purpose. I wouldn't have sales targets, I guess, but I don't know. I haven't really have thought. I think it depends on how it's looked, but I would just be worried that the nonprofit, the requirements for the non-NPO to actually be a nonprofit to be satisfied. The other thing is, I guess it's more for charities thing too. That's the income tax act, right? There's for example, there's Charities Accounting Act rules. There's other provincial regulations that affect how much one pays. And I don't have those rules at my fingertips, but you should check those with respect to paying employees and directors, which for tax purposes is an employee.
Thanks, Kevin. There were also a number of questions relating to employers in the public sector, and I mean we've spent an hour and a half discussing primarily a focus on the private sector, and so we haven't touched on the public sector because that you could have an entire separate presentation for that. And in fact, we do have an entire separate presentation on that. We presented one. It's recorded and it's available I believe complimentary on our website. So if you're interested in more information from a public sector perspective, I'd encourage you to go and sign up for the recording. If you email me, we can send you a link to the presentation. But the title of the presentation is "Show Me the Money: What do Ontario public sector organizations need to know about employee compensation?" So again, I encourage you to sign up, and you'll hopefully have your questions answered through that presentation there. There was a few questions about notice periods for executives. I'll speak to that one. I think, Alix mentioned that one of the goals, or typically what's common, is you'll have written employment agreements that clearly set out what the termination entitlements are, with the idea that you want some certainty. You want to provide the executive with a compensation package that they are comfortable with at the outset, and not leave it to be determined by the courts or negotiated afterwards. So the goal is to not get into what is a reasonable notice period, but from time to time, employments might not be agreeable or enforceable. You might have agreements that don't have a termination clause or a proper termination clause. And so what do notice periods look like nowadays for executives? I think it's not uncommon, or it's common to see sort of 12 months as the lower end for a top level executive. It's pretty rare to see something that's less than that. It's possible, but it wouldn't surprise me to see a 12-month notice period for a very short service executive, just because of the difficulty in finding another job in less than that period of time. Upper end, historically, the upper end for common law notice periods in common law jurisdictions has typically been 24 months. We're starting to see nowadays there's the odd case here or there where you're getting above that, 28 months, maybe a little bit more than that. But those are sort of exceptional cases. Another question was asking about the major differences in compensation plans between the US and Canada. From my perspective, I think the biggest difference is you'll see it's more common to see restricted stock plans in the US, whereas it's more common here to see restricted share unit plans or performance share unit plans. Reason being, as Kevin mentioned, that the tax applications are different. If you were to implement a restricted stock plan here, when the stock is granted, it'll trigger tax events. And Kevin, correct me if I've misspoken, but
that's right. There's also, depending on how it's restricted, there can be issues if the employee is forced to sell the shares back if that's one of the restrictions. So we worry about that too. Like if one of the restrictions means that they had to kind of give the shares up. I mean, we could live with it, but there's it's an extra concern. It's one of the reasons why it's not the first thing we would go do in Canada.
We had another question about compensation for contractors. Maybe I'll turn this one over to Alix. The question is essentially, are there unique considerations for executives who are providing services or structured as contractors, through their own incorporated company?
I mean, we do see it. We do see executives providing services as an independent contractor. I mean, the first issue you have is whether or not it's a properly classified relationship. The risk there is always that the Canada Revenue Agency will question the legitimacy of that relationship. If it walks like a duck and quacks like a duck, is it a duck? And so is it really an employee relationship, and therefore you haven't been doing proper withholdings? The other thing is, obviously, from a board governance perspective, they don't always love to see contractors in a role that have fiduciary obligations for an organization. In some smaller organizations, we do see contractors in those positions, and they usually have agreements that have obligations in them that would probably not meet the CRA guidelines of being completely, independent, arm's length contractor. And so there's some risks on that perspective. We do see contractors having access to equity plans if the plans themselves allow for non-employee participation. So you have to make sure that the underlying plan allows for that. I'm not sure if you want to add anything else to that, Anthony.
No. I mean, it looks like we're out of time. We've used up all hour and a half. So with that, I think, Alix, do you have any closing remarks, or No. Okay. So on that note, I mean, we hope you found the session informative. I believe it's recorded, so you'll have access to it afterwards. So you can have a rewatch. The materials will also be available. Some information on the slide here as well in terms of getting credit for CPD. And of course, if you have more detailed questions, feel free to reach out to your regular lawyer here at the firm. So on that note, have a great afternoon, everyone. We'll talk to you soon.